These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
All righty. So we're going to give you a little breakdown. We're going to do this quickly because we've covered the public trust, private trust several times in past seminars, the Chicago one and the LA one. We went into great detail. This time we're going to give it and again, we're always updating this. So here's a little lesson in critical thinking for you. We change our stuff all the time. Any of you who have listened to the Living Temple audios, the Monday night downloads, you know, as time goes by, our stuff shifts and changes. You're not to take what we share as the gospel truth. You're to take it as a foundation for critical thinking. So that we're not telling you what to think here. We're giving you information and data such that you can relearn how to think. You know, we were talking earlier about the public school system. The public school system doesn't teach you how to think. They teach you what to think. They give you some data, like we dropped bombs on Japan during World War II. Here's what we want you to think about it. It ended the war. It did this. It did that. It was necessary. So you take on a political idea. What is politics? It's opinions. So you take on the official opinion of the state in public school. So they're teaching you what to think. Don't take what we share as what to think. Take it as just a neutral event, neutral information from which you can critically think about it. I come up with my best stuff when I analyze the information and think and create from it.
You're going to have to come to a fundamental understanding and realization of the facts and the foundation for yourself. I was talking to one of the guys during lunch regarding counteroffer. I said, well, what's a counteroffer? He says, well, it's a statement, kind of gave a sort of a definition about it. But to know the exact meaning of what it is, that it's a statement by the offeree which has the legal effect. Well, what relevance does legal have? Well, you need to understand what lawful means and what legal means. What under God means, what under man means, what substance means, what form means. Legal means in form, essentially. Are you legally married? Some of you are legally married. Some of you are together yet married, lawfully married. And so it's going to be important for you to take these things you're learning here, and if you parrot them, just you repeat what we've told you, because it sounds real good, but you don't understand why you say it, You're not going to understand why you can or why you cannot get remedy when you're in court. Or you wouldn't have the foundation. Well, oh, gee, Jack and Gordon and Brand didn't give me a conditional acceptance for that offer from the judge or the prosecutor or somebody else. I did a deal with a major retailer, and I sent my hello, how are you, what I call when I started my administrative process, for failing to cash a check and wanting a Social Security number. And it was all over about $186.40 check. And the long and the short was, I got a call from that major retailer attorney. And he says, this is George so-and-so from Bentonville, Arkansas. And I said, how are you doing, George? He said, great, Gordon, how are you? And he says, I got your paperwork, but I don't even know what you want. There's no numbers here. There's no nothing. Now, I know all the numbers are there. Now, what was he doing? Fundamentally, I knew that he needs an argument. He needs to know if I'm a debtor or a creditor. It's that simple. But if you're trying to think, oh, God, Gordon didn't give me one for that, if the guy calls and says that. No, you conceptually understand they're looking merely for an argument. And understanding that, I said, gee, George, must be my bad. I thought I'd put it in there. Let me get my copy. And he says, oh, here it is. I said, great. And he goes on to say, well, you've made mistakes, haven't you? And my guy was speaking and goes, so he's telling you made a mistake. They made a mistake. Well, how are you going to answer that? I said, well, gee, George, is it a mistake if the employee, the supervisor, the store manager, and the district manager do it? Just a question. When I had the warden arrested, I just had a question to the federal district court why he shouldn't be arrested for threatening. Just a question. I didn't say he should be. I just wanted to know. Shouldn't he be? Show cause why he shouldn't be arrested for threatening. I'm just curious. That's what they're testing. I had a deal with the IRS. They came by my home after having a summons delivered. Within a week, they came by for another one after I put in a conditional acceptance and did a few things to put off the summons and allowing me the time to administratively remedy the matter. And 7:30 at night, I get a knock on the door. IRS. Well, please, come on in. No, thank you. Well, can I get you something to drink? No, thank you. Just bringing you something. I said, great. Is it the same one you had delivered last week? She says, yes. I says, well, give it to me. I'll take care of it. And she says, where do you work? I says, why do you want to know? She says, where do you work? I says, why do you want to know? And she stormed away. I called Jack and I said, Jack, I had a nice visit from our friends. Do you want to come by and say hi? Because they already delivered the summons. Why are they doing it again? They had a red rubber band in it, all sorts of neat stuff. Very important documentation. And Jack says, and what'd you say? Well, I invited her in, of course. Tried to get her some water. Tried to help her out. He said, nice, you passed the test. What test?
Second test.
My first thing, I sent the paperwork in claiming to be a creditor. We got one witness. Didn't they just want to come out and see what was going on with are we really dealing with a creditor? What else would it have been? These themes that you're going to learn. So you've got to learn to think on your own. Get the fundamentals. If somebody's arguing with you, it's for a reason. Whenever you've eliminated everything else, whatever remains, however improbable, must be the truth. Boy, you're going to need to find some fundamentals and stick with them. So, anyway, Brandon, let's get moving along. So, he's telling you, understand why you do what you do. And it's not going to be difficult. You just get these principles down. You don't fight, you don't argue, you don't explain, and you know why you counteroffer. You don't counteroffer just to ward them off with a cross. You counteroffer to make a contract, or you ask questions to help bring harmony. What is the purpose of law? What is the purpose of contracts? Why do we have laws that say, don't lie, don't cheat, don't steal, can't burglarize, don't do this, don't do that? Merely to bring harmony in our lives. Because most of you need prohibitory laws. We can't give you the higher law that says if you do this, this, and this, you get the world. We got to tell you to stop doing this, stop doing that, quit lying, quit cheating, quit stealing, quit doing all these things. What's the point in trying to teach you something higher until you get the basics down? And I'm not speaking at you. It's just in generality. The people, what's the point? So these fundamentals you're going to learn are for you to think on your own. Because you will not, and like Jack told you earlier, we go into court, all our students run into different things. We ask, where's the original charging instrument? Bam, they bring it right out. And our guys go into shock. They don't know what to do with it. We had one guy took it home. Well, my assistant, a great guy, Deepak, he was great. He held up like a rock. He goes in, he asks for the instrument. They give it to him. He looks at it, turns it over, checks it. It's the real one and gives it back. I said, what you doing? Why didn't you sign it? I don't know. I just locked up. This isn't hard. It's not rocket science. And other ones we have a client that's trying to get out of jail. We got him ready, and they brought him right out, like within a few days of the filing, put that charging instrument in front of him. He got out his PIN, got his name signed to it as a starter, and they took it away. Threatened to charge him and everything else. Of course, they haven't done that. He's not defacing a government instrument. How can being paid for the thing be a defacement? They just said if you deface it, it could be a crime. Well, if I deface it, I'll let you know. He didn't say if you enface it, that's to print or write on a check, a bill of exchange, money order, etc. He said if you deface, well, I'm enfacing my banker's acceptance. So open your mind to these things. Try not to memorize. Just memorize the principles, why you do counteroffers, why you ask questions, why you don't argue. And everything will fall into place. That will make it easier for you to deal with it. And you'll have to then buff up and get your repertoire of conditional acceptances and when you ask questions and when is that. I dealt with this major retailer and the attorney calls. And he says, it's not here. I said, oh, it must be my bad. Oh, here it is. He says, then he goes, well, you've made mistakes, haven't you, Gordon? I said, why, of course I have. Well, why are you holding it against so-and-so? I said, is it a mistake if the employee, the supervisor, doorman, boom, 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 boom? Then it's time for a question. I didn't conditionally accept on proof of claim that no, I was just being, it was real friendly and easy. Learn to relax at it. So.
Yes, definitely learn to relax. So what we're going to do is we're going to go over briefly the structure of the public trust and the private trust, and then I'll give some distinctions of a public trust and a private trust.
Could you say it another way, Brandon? Like there's private side, public side, republic, democracy, then there's private international law and public international law. So really our ignorance kind of stems from not being familiar, that there's a whole lot more to just, there's just a simple black and white, but there's numerous shades and a whole lot of thing here, right?
Absolutely, and there's multiple layers to it as well. So what we're starting with is giving you the general public trust and the general private trust. And like Gordon, to equate it with some of the terminology he used, we would equate the private trust with a republic, a self-governed society, and the public trust with a democracy, and the specific private trust would be the private trust that was created on your behalf, evidenced by the birth certificate, and a public or specific public trust, which is the straw man resulting trust of the contract between your private trust and the United States corporation. The public trust that we call the straw man is a joint venture.
Are you just saying like the name, Brandon, like the all-cap name is kind of what you're talking about?
Yeah, if you were going to make distinctions about the all-caps name and the upper and lowercase name, neither of them is a real man. They're both titles. One represents a private trust. A private trust in law is a natural person. How many people knew that?
Because they refer in the law dictionaries, Bouvier's, etc., they talk about law equating to natural persons or artificial persons.
And the public trust would be the artificial person. The private trust is considered a natural person. I got that right out of a trustee's handbook. It was like a jaw-dropping moment, like, oh my God, truth in a book? So it meant a lot. It was significant to me because in the public, a natural person can get a driver's license, right? A natural person can contract and get a Social Security number. Did you know you could form a private trust named Joe Bob and go get a driver's license with that natural person? You can get a Social Security number for that natural person. You could operate 3, 4, 5 natural persons. They're all private trusts. So we're going to make a couple of distinctions here because I know that a lot of times it gets confusing when we start talking about trust because most aren't familiar with how a trust can be set up and how one trust can be the trustee of another trust. Your private trust serves as the trustee of your public trust. So understanding that trusts can literally be layered inside one another. A court case is literally a trust inside the state of California trust, inside the United States trust, with every party in there operating 2 or 3 trusts individually. So we're going to make a couple of distinctions on the trust. We'll let Jack do the breakdown of notice I use specific articles. I call this the private trust and the public trust. Maybe more appropriate to say this private trust and this public trust. And then a distinction that your individual or specific trust I would call a private trust or a public trust.
One of the things you're going to want to get your hands on is a grammar book. Ignorance and freedom cannot coexist. So getting back to some basics of grammar, because you're going to see court documents that say this court and the court, 2 different groups and they're all together. And when Brandon's telling you the public trust, this public trust, a public trust, he's making a distinction, and law is very, very careful that way also. They do not just throw words around, much like we do as a general public. That's sick. I had to ask my child that the other day. They go, that's sick. And I said, what do you mean by sick? Because I hadn't heard the term yet. What do you mean by sick? Well, it's really cool. I said, okay, that's what I thought you meant. Okay, so sick means great. Okay. I just had to, and of course, what do? We text on our phones, and here's all this language. THX means thanks, and this means that. And my buddy, there's a book on it. So there's language in law, there's language in astrology, and words in one language or in one science don't mean the same as another. You and I have been taught generally what's termed common parlance. We haven't been taught the language of law. So when a judge says, who are you, in common parlance, I wanted to know your name. Who are you? Jack Smith. Not in law. That isn't what the judge is asking you. He's asking your capacity. Who is defined as what or which person or persons? He's asking your capacity. Authorized representative, paramount security interest holder in all property and collateral, both registered and registered belong. Who are you? What is your capacity, he asked. Do you know that? So it's going to help you if you get that dictionary like I suggested and you start understanding. We got to go back to getting some basic grammar and understand the language of law. And I think if somebody's got a Black's Law dictionary, may, what does may mean? May oftentimes by the courts shall be construed as shall or must. So when I go into court and I say, if it please the court, may I enter the bar under said terms and conditions, I wasn't asking could I. I said it's going to be under that or it ain't happening.
To be permitted to be a possibility. Loosely is required to, shall, or must. So there's 3 definitions of the word may in Black's Law Dictionary.
You get Black's 5th is different than Black's 8th or 9th.
Yeah, this is
different than Bouvier's. What you need is and law doesn't change, so don't worry about it. But when you get that, I use a lot of different dictionaries because I need to have things, they process in my mind differently. I need to hear something a certain way. I didn't really grasp security interest until a neat definition out of a little thin Webster's Law paperback I'd gotten sent in to me. And it said it is a personal lien, or a lien on personal property created by an agreement. And that's said differently to me, so I can use it in such a variety of ways that I couldn't have prior to that. I understood it basically, but it wasn't until I got it from that dictionary. So it must have been the 7th or 8th one I looked up that term in. But that one really brought it home. And like Brandon said a little bit ago, when he saw in a trustee's handbook, natural person and artificial person, it hit him. Now, I've seen it in Bouvier's and other ones, and he may or may not have. But when it came through on a trustee handbook, it said something different. So we go back over the same material we've been over a year ago, 6 months ago, because it comes in way different each time you read these things as your education expands.
Yeah, because now when I read natural person in a law or a law book, I read it as private trust. That's what they're saying. Because what you think of a natural person or a living man and woman does not exist in the fictional world of law. It just doesn't exist. They cannot even interact with living people. It's forbidden by their own structure.
They have a set of rules. We play chess a certain way, but they play chess differently. Pawns move like horses, kings move like castles, and castles move like kings. So once you learn the rules, life gets easier.
Excellent. So we'll move forward with this, and then we'll make the distinctions of being an executive trustee of my public trust.
Okay, what we have here, understand to begin with that everybody has the right to hold title to property in yourself as a woman or a man under the common law. If you had both parts of title, title comes in legal title and equitable title. Legal title has the nature of having control over the property. You can make the rules and regulations for its use or possession.
One quick sec. Legal title, what he's talking about, you've heard the term. 9/10 possession is the law. Where's the other 1/10? In your car, the state has the legal title, 1/10, and they actually tell you, keep current tags, keep insurance, keep the tires up. They get to tell you what to do with it on that basis. But the other 9/10 possession, the equitable that you have, you get to eat McDonald's in it, piss in it, leave crap in it, wash it, not do it, do what you will with it, transfer ownership of it. And so in a trust, what you have is divided title. And the thing he's talking about is when you can get both of those titles, you got a whole different world.
Okay, so legal title gives you control. You can write the rules. You also sign the document for transfer of ownership or title. Okay? Under the equitable side, you get the right of use and possession. As long as your use and possession is within the boundaries of the rules that are set forth by the legal title holder.
And if it is within the boundaries, there is not necessarily a right to possession by the legal title holder. This is something we've run into in unlawful detainer cases, where we walk in showing we have a legal title. Notice I said a legal title in the property. And the judge looks at me and he says, this isn't about title.
It's about possession.
And you can have legal title, doesn't mean you have right to possession.
If you had legal title and you rented the property out and it's during the proper rental period and the tenant in there paying the rent is following all the rules, then the legal title holder has no right of possession at that time.
The state can't take your car. You have the equitable possession.
Unless
as long
you
as you're
did
following the
something
rules.
wrong.
Right. But if you're following the rules, they don't have a right to take it.
Okay? So the important thing about a trust is it splits the title in two different entities. It's not a trust if the same entity has both legal and equitable title. If it is land and you had both legal and equitable title, it's called allodial property. And having allodial property means there is no government land tax to be paid. Why would you pay a tax to the government if you've got both sides of the title? The fact that you're paying a property tax shows that you do not have both sides to the title. So obviously the title is split. When the title is split, it is said to be owned in a trust and not through one entity. So we're going to talk today about trusts, which means that a title is split. The same entity cannot hold both legal and equitable title, one or the other. If the same party holds both, then it is not a trust. So what we're going to do today is we're going to talk about a trust, and this is a roadmap or a model of what's happening in America. In fact, it's happening in all the commercial nations of the world. And you're going to find out that you only have, at best, part of the full title to whatever it is that you think is yours.
But you can get full title.
Yeah. But you have to be aware, first of all, of the problem that probably you do not have full title right now. Now, when it comes to the trust, there's generally three entities in the trust. One is the grantor or the settler or the party that creates the trust. That's shown in block 1 here.
Now, hold up. How do they create that? Are you saying that the grantor or settler puts the property in?
Trust is a contract between parties.
Now, what's the position of the grantor? He's
the offerer of the contract.
So he puts the property in.
Well, a trust usually describes the disposition of property. So the property is the subject matter of the contract.
So if I had a car and I put it in trust, I'd be the grantor or settler of that trust?
If you were the one creating the contract and then placing the title to the car into that trust, then you would be the grantor or the settler on that trust.
Oh, so if I put money in my children's trust or something, I'm the grantor settler?
Correct.
Or if I'm putting a promissory note to buy a home or a mortgage or something, I'm the grantor settler there too?
Right. Whatever the property is that goes into the trust is called the collateral that's introduced into the trust. It's the property. It's the subject matter over which this contract is going to be resolved. And the parties that are involved in the contract are generally the guy that offers the contract and places the property in there. The second party is the trustee. He is the one to whom the offer is made, and the trustee is now going to take on the responsibility of carrying out the terms and conditions in the contract of the trust to be the protector for the property that is put into the trust, which is the collateral.
So if I went and, so I could like go to a car dealership and technically I could get the real full title if I wanted by paying all cash or something and get what's termed the MSO, MCO, and I could then turn that over to the state as the grantor settler. They become the trustee, right?
Correct.
Okay.
And whoever's in possession would be the beneficial
He's the
interest
beneficiary.
holder.
So the third party is the beneficiary. He's the one that gets the use of and or possession of the property in the trust, the collateral.
Also termed equitable interest.
He's the equitable title holder. And so when you get a certificate of title back from the Bureau of Motor Vehicles in the state, if you look it up in the dictionary, the one that issues a certificate is a legal title holder, and the one who's named on the certificate is the beneficiary. He is the equitable title holder.
And if you look
the state of Arizona issues out a certificate of title, and they issue it out in Gordon Hall's name. The state is then the trustee, and Gordon Hall is the beneficiary.
And if you look in trust, typically a trust that has been structured the trustee will issue two types of certificates. One is called a certificate of beneficial interest, which goes to the beneficiary, showing that the beneficiary has the equitable interest in the property, and the trustee will also issue a certificate of capital interest, which is the grantor's certificate, showing a controlling interest in the property. And the trustee, under the what's called the indentures of the trust, which are the grantor's instructions, contract with the trustee, and how the trustee is to handle the property, because the trustee is really serving as the legal title holder, because the trustee controls the property and distributes any benefits or equity to the equitable interest holder or the beneficiary. So really, when all certificates of title, look at them as, okay, there's a trust going on here. By the issuance of the certificate, who's got the beneficial interest? That's the beneficiary. Who's got controlling interest? That's the trustee. Who has a capital interest? That's the grantor.
Okay, so if it comes to the automobile, what happens is when you go down to the Bureau of Motor Vehicles and register it, you've just issued a grant to the state to be the legal title holder, so all of their statutes involving the ownership, operation of motor vehicles are the trustee's rules for possession and use of the automobile. And who is the beneficiary? Your straw man corporation, which is the other Alice. It's not the living man or woman, because everything involved in the trust here does with titles of nobility, and it's all a fiction, and the parties in there are just plain roles in this. So the state creates all the rules for the use and operation of the vehicle. You've consented to it by a contract when you registered, which means you placed it in trust and made a grant to the state. You did it voluntarily. Your straw man is enjoying beneficial use as long as he obeys all the state rules and regulations with regard to anything dealing with that collateral, that motor vehicle.
When you go down and buy a car, you'll realize that they ask you for power of attorney. If you buy a new car, they ask you for power of attorney. What are they doing with it? Did you ever ask them? They're actually signing the MSO and granting it over to the state on your behalf.
The dealer needs your permission to act in your capacity to give it to the state. That's what you did.
So in that case, what is your position in that trust? Grantor and beneficiary. So see, the capital interest holder, if property is liquidated, the capital interest holder gets reimbursed. If the property changes possession or is sold by the equitable interest holder, then the grantor still has a capital interest in the property. So what happens when you sell a car is they dissolve the trust by having you endorse the trust certificate, the certificate of beneficial interest, giving up your beneficial interest.
The certificate of title?
Yeah, when you sign, remember you're going to go sell it to somebody else, so don't they have you put your signature on the back side of the certificate of title in front of a notary? But then do you take it down to the Bureau of Motor Vehicles and turn it in? No, you give it to the new owner, and he goes down and cancels your trust.
And then for about 5 minutes has control of the car until he fills out a registration form, creates a new trust, and gives them legal title again.
Question, does it matter if the signature's on the back or the front of the document?
The front of the document is public, the back of the document is private. You are in the public in the front because they are noticing that you're a beneficiary of a public trust. If you want to recover the property again, you go to the back, endorsing the back. By endorsing the back, aren't you taking back legal title? But in the public, do they recognize legal title? No, so you got to endorse it on the back.
Like Social Security card, I guess.
Yeah, they're doing nothing wrong. Now, when the law enforcement officer stops you on the road, why is he stopping the car? The state has legal title. He's an officer of the state. They're investigating what you're doing with regard to the property that was donated to the state. They want to know if you are in line with all the rules and regulations for the operation of state property. Is it illegal, unlawful, or a harassment for the officers of the state to stop their property to investigate whether it's in line with their rules? No, it's part of their function.
Do you have the right to travel in their property without do whatever they want you to have, a license or whatever? It's their property. So don't get your panties in a wad when they pull you over and you got a right to travel. What are you doing stopping me? We're stopping our car. We have that right. It's our property. We'll do what we want with it. Now they're not that blatant about it. They prefer you had a little infraction, but that's okay. We're just having the middle of road stops.
They're serving the role of nominee of the executive trustee. See, an executive trustee of a trust can allot duties of the trust. So like they said, there were special rules that the trustee is charged with making sure the beneficiary follows. However, that executive trustee can dole out responsibilities and duties of the trust to nominees. And so a highway patrolman or a police officer is serving as a nominee to the executive trustee of the trust. So they may not have all the powers of trustee, but they've been granted certain specific powers and duties of a trustee.
Let's say someone like Brandon is traveling down the road and he's behind the wheel of a state-registered vehicle. And they stop the state-registered vehicle to do an investigation, and they find out that this particular party behind the wheel is not licensed, but they have no reason to believe that he's not responsible. Therefore, if they found, let's use the term, a sovereign having full responsibility behind the wheel, even of a state-licensed vehicle, then it just might be that the agent of the trustee may determine that as a responsible individual, but not licensed. That merely means that if an accident or damage were to occur, the responsible individual would be personally liable, and the state could recover, so we'll let him go on. So just because someone is sitting behind the wheel and it's a state-licensed vehicle doesn't necessarily mean that if the party behind the wheel is given assurances and playing a role of a responsible individual doesn't mean that the trustee or his agent might arrest him for violation of the terms and conditions of the trust. Because after all, it's about knowing who you are and being responsible. See, the problem is if the state has the legal title holder of that vehicle, and they have reason to believe you're a non-licensed driver, and you cannot rebut the presumption that you don't have responsibility, would they allow the vehicle to go down the road when they're responsible, knowing that you show no responsibility? Or on the other hand, if you could show that you've got personal responsibility and you have assumed the role of liability, even if that vehicle that they have legal title over is in an accident, they may let you go knowing you're on the private side and you're actionable.
Did you have insurance when the police car stopped you in your car?
Always.
So even though Brandon had no license, he had insurance papers. Did they ask for the insurance papers?
She actually didn't ask for them. In California, they've asked me for them, but the guy who stopped me in Arizona didn't ask for it. But I think that goes right along with it. It shows that there was responsibility there on the vehicle. And in reality...
And he offered his passport right up. He said, I don't have a license. How about a passport?
And also, if I were going to take legal title of that vehicle, I would no longer use insurance. I would put up a private bond on the vehicle. However, if it's registered with the state I can't really use the private bond, but I would use insurance. So look at the distinction of, am I using this vehicle for non-commercial, private purposes? Well, then it should not be registered to the state, but I should have my interest registered, meaning I'm going to have maybe a UCC1 that I carry around in my glove box that shows that that VIN number and the vehicle associated with that VIN number I have controlling interest in, and I would put up a bond with the Secretary of State for any damages that may be incurred associated with that vehicle. So, see, there's a distinction of how I would operate on the public side, how I would operate on the private side in regards to that conveyance, I should say, not vehicle, because vehicle's actually got a commercial connotation to it.
Okay, let's go back to the map now for what we want to do. We introduced you the concept of trust. Now, above the line is what we're calling the private sector, the private trust. It's in the land of the republic. It's under the law of the land, which is generally spoken of as common law. The area below the line is going to be the democracy. The democracy is going to contain a public trust. The democracy is run under the presumption of a law form known as Admiralty Maritime Equity. Now, we're going to fill these in and show you exactly how this is going and why we're putting it in this capacity. Is everybody aware that there are basically two 13th articles in amendment to the Constitution of the United States of America? The first 13th article in amendment was proposed in the early 1800s. If you Google this on the computer, you will get the complete story, but they will allege to you that the first 13th article in amendment was never passed. Remember, if you propose an amendment, a certain minimum number of states have to approve it in order to make it law. Now, prior to the Civil War, many of the state archives had documents showing that the first 13th article in amendment had been approved officially as the 13th article in amendment. After the Civil War, most all of those records were purged. And the first article in amendment after the Civil War was called the 13th article in amendment. Both of these 13th articles in amendment are the same amendment, but from a different position. The first 13th article in amendment basically said there are going to be no titles of nobility operating in the United States. A title of nobility is someone who owes an allegiance to a foreign sovereign or government. An attorney is a title of nobility. An attorney is an esquire, which is underneath a knight, which is under the King or Queen of England. And it was for that reason in the early republic that they did not want officials in the public government that were carrying a title of nobility and responsibility to any foreign government. So the first 13th article in amendment, which applies to the republic above the land, said we will not allow any attorneys to operate in the public side of government. The second 13th Amendment, passed after the Civil War, said that there is no involuntary servitude except punishment in a prison doled out after being duly convicted of a crime, which is an oxymoron because you were convicted of a crime because you volunteered anyway. The second 13th Article Amendment applies to this area below the line. That area below the line in public government did not become relevant until after the Civil War. Why? Because before the Civil War, the states were supreme and the national government was created by the states and subservient to the states. After the Civil War, the states lost their sovereignty and were subservient to the national government. Is the national government restricted to operation within the confines of the provisions of the Constitution of the United States of America?
Yes.
In public international law, yes. In private international law, no.
There you go. Did you understand the difference? Okay, the question is, was the national government operating out of the 13-mile square constrained to all of the same restrictions as it applied to its governance over the sovereign states? And the answer was?
In public international law, you have one answer. In private international law, you have a different.
See, the national government was not constructed to deal with the people. The people are not a part of the Constitution. We had an attorney, New Mexico, Arizona, that brought a lawsuit against President Obama. Why? Because they said under the Constitution he has not presented a birth certificate showing that he's eligible to be President of the United States of America pursuant to the Constitution. And it stuck in that federal district court for a period of time, and the guys are going, yeah, they're going to hear it. And then all of a sudden, 5-7 months later, the district court judge threw it out. Why did he throw it out? Very simple. He said, the attorney is not a party to the Constitution. He is neither the national government, nor is he one of the sovereign states. And as a person or a U.S. citizen, he has no standing to challenge anything under the Constitution. Bye-bye. It's gone.
This is a document called Cooperative Federalism, and it's by Gerald Brown. And this is a really unique document for helping to clearly understand the United States government, the federal government, how it was formed, how it differs from the states. But listen to this just short one, and this will help explain. So how is it that the states of the Union are not foreign to the United States under the principles of public international law, but are foreign to the United States and each other under the principles of private international law? Public international law deals with the authority the states of the Union delegated to the United States government to represent American interests outside of American society. Private international law deals with the role of the federal government within American society, where federal legislation might conflict with state law and where the delegation of authority to the United States government is limited or absent. This document, give me just a moment, this document goes into great detail the purpose and the formation of the federal government and trying to understand what do they mean, United States. The Supreme Court, in a court case called Hooven and Allison Company versus EVAT, 1945, said thus: the term United States may be used in any one of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. That's the 10-mile square known as D.C. among New York, Pennsylvania, New Jersey, etc. Number two, it may designate the territory over which the United States, over the sovereignty which the United States extends. Guam, Samoa, Puerto Rico, etc. And 3, it may be the collective name of the states which are united by and under the Constitution. So it sounds very complicated, but once you get into, this is another little treatise I recommend highly. It's about 73 pages, octavo size, that means about 6 by 9, big print, easy to read. And it's so informative. It gives you a real understanding. And it'll go into a couple of landmark cases about Congress and their authority. They have plenary power over the District of Columbia and its objects, and it extends all over the Union. And the other one is an absolute exclusive legislative power over the District of Columbia. The Patriot II Act. All of these wild laws that seem to violate the Constitution are passed merely for D.C. and its objects, which extend all over the Union. Are you a U.S. citizen? Sorry to hear that. I'm a Californian. I believe we have another Californian. I believe we have an Ohioan. And we have many Georgians here. That is a country. And you heard this document refer to it as American society. The United States, the Supreme Court, is not a country. It has been ruled. It is not a country. 28 U.S.C. 3002, Section 15.
Corporation for gain and profit.
It says in that the United States is a federal corporation. 28 U.S.C. 3002, that's 3002, Section 15A, subsection 15A. But if you get cooperative federalism, it goes into all of this in such detail, and in layman language, this is such a treat to read. So if you'll add that to your library, your education will move quickly. If you don't have cooperative federalism,
It's on the private network.
it's on the private number. If you email me, some of you have my email. Some of you can call me. You know, we do a lot of things. I'm at 480-286-3340.
Oh.
So, like,
just
don't just
put
call me
that
to be
out on
talking
the
and yakking. You know, I
audio.
do this for a living, by the way. So, but if you need a little stuff, email me. We,
All right, be ready. Be ready. You just put it out on the audio. I've made that mistake.
Well, don't call unless you
There
want
ain't no
some
one
business.
doing that.
Please call him, because then he won't be calling me, and I'll have at least a moment rest.
I don't have a number. But get cooperative federalism. You'll really like it. We'll get that to you. It doesn't take much to move your education from kindergarten to right up into junior high and be able to start taking care of yourselves a little bit. It doesn't mean that the government doesn't have rights. They have complete and total plenary power over the District of Columbia and its objects. That means U.S. citizens.
And it had to extend because the United States was actually created by the post office, and the post office designated that it shall not, no entity or no person of the government shall operate outside the District of Columbia, that no position shall be held outside the District of Columbia.
So all
what
the
did they
positions
do?
are therein.
So basically, in order to make it so that you or the U.S. citizens could operate in the District of Columbia, they extended the District of Columbia through the use of zip codes. So zip codes are extending the District of Columbia all over what you think of as the United States. So it's basically to keep those who choose to operate as U.S. citizens from violating the law of being a government employee operating outside the District of Columbia. They had to extend the District of Columbia all over the United States.
But it's above the ground.
And they took your incorporating documents, which are the birth certificates, and they lodged the titles in storage within the 13 or 10 square miles and the territory, so you're actually incorporated out of the national federal zone. So your 14th Amendment straw man, which is your all capital letter name, is residing within the national domestic jurisdiction.
Us three up here are without the United States in the Republic right now. Some of you are down there in the
You've
democracy.
hereby been given notice.
Okay? Okay, let's carry on with what we're doing. We're talking about the 13th Articles and Amendment. This is going to be absolutely critical when we start talking about administrative process, because we're going to get a lot of questions that we're going to start our administrative process. We're going to do A for V, R for V's. We're going to send it into public officials. And do you ever expect to hear from them? No. Why aren't they going to respond to you? Because your process is coming out of the republic. And are they titles of nobility? You bet. If they answered you and argued into your territorial jurisdiction, what did they just do under the first 13th article and amendment?
Treason.
Committed treason. They're going to have to go out and hang themselves. That's a real good reason why they're not going to write you back.
I guess that's voluntary compliance.
Okay? But, look, if it's treason for them to go into the republic, what is it for you to go into the democracy?
It's treason to the republic.
Treason to you, too. What have you been doing your whole life? And you wonder why you're in trouble? My God, they should be hanging you instead of just fining you or throwing you in prison. You claim you lost your land and the public's doing whatever they want. That's because you have abandoned your land. You're going into the democracy. Didn't they warn you on the second 13th article and amendment? You come into our democracy and you're going to serve us. Isn't that what they told you? Who's bad? We said, you come into our land, we're going to kill you. They said, we're a lot nicer than you guys. You come into our land and you're just going to be our slaves. Isn't that the same amendment? One's a warning for them not to come into us. The other's a warning from them not to have us come into them. But you don't understand what you're reading and you don't know what you're doing.
There's a thing in law called inclusio unius est exclusio alterius. The inclusion of one is exclusion of another. When they said there'll be no involuntary servitude, they just told you there's voluntary servitude.
Yeah. They issue a summons or a warrant to your straw man. Straw man exists down here in the democracy, into their court on a criminal charge. You go into the court. The judge's first question is, we're here today in the case of U.S. versus Smith. Are you Smith? Yes, sir, Your Honor. What did you just do? I waived the second 13th article and amendment. I said, I'm here to serve. Well, fine. We're going to convict your straw man of a crime, and under the second 13th article and amendment, you just volunteered to go to prison. When did everybody volunteer to go to prison? When they said, I'm here as the defendant. Now, the judge needs a second witness, right? So after he said, oh, you're Mr. Smith, do you understand the charges? And you go, yes. What did you just do? Understand. Do you stand under the account? And are you going to make it good? It has nothing to do with your mental capacity to figure out whether the wording in the indictment is right. To understand commercially means, are you going to pay this charge? And you go, oh, yes, I'm going to do that. And then the judge says, how do you plead? Not guilty. What does that tell him? I'm going to fight the charge. I just told you I was going to pay. What, are you crazy?
What's guilty mean? Gilden to pay. You just told him you're not going to pay.
So you understand the charge, you agreed to pay, and then the next word you said, I'm not going to pay. Okay, listen, this man's double-minded, which means he's a debtor, which means he's going to prison. And he volunteered twice, so that's it. We don't even have to hold a trial. Let's just go out and hang him. Oh, well, maybe we better hold a trial so he doesn't get a clue of what he just did.
We can't run this game, Doc, if you don't
Have we talked
do the
about
show.
evidence against him? We don't need no stinking evidence. He already volunteered. Under the second 13th article and amendment, we warned him not to come here. He came. Then we asked him his name, and he said, I'm the party that's liable. And then we said, are you going to pay? I understand, Your Honor. Well, are you going to really pay? Hell no. Take him to prison.
First, let's get him an attorney and help him out, and let's let the show go on, right?
No. They ask, are you going to pay? When they say, do you understand? And then they ask, how are you going to pay? Right? Don't they ask, how are you going to plead? And you say, oh, I'm not. I changed my mind.
You see what you got going against you? And all these crazy patriots out here are blaming government and attorneys for everything that's going on. They don't even have knowledge and understanding of what it is. Now, maybe the government's playing a little bit sneaky and tricky on here, but you know, if you are competent as a master, don't you think you ought to be a little bit smarter than your servants? But if your servants are smarter than the master, and the master is acting wacky as can be, what's going to happen in this scenario? It's a disaster. So our problem has been lack of knowledge. We don't know history. Have they played these games before? Yeah. What about the Inquisition? Did people die in the Inquisition? Why did they die? Because they wouldn't go in and confess, right? Do you understand that an Inquisition is admiralty maritime? But they're on the land. They're supposed to be under common law. Under common law, aren't you presumed innocent until proven guilty? Yeah. Under admiralty maritime, what's the rule? You're guilty unless you prove yourself innocent. So under the Inquisition, they assumed you were guilty. All they wanted you to do is rebut the assumption. Everybody argued or stayed silent. What does that mean? Guilt, go to the rack.
Yay.
Got a question to you right there, Jack.
Okay.
Question over here to the right.
Question.
Yes, Jack. I was wondering if you can clarify, I think I understand this, but I was just wondering if you can clarify. You said that because of the 213th, or the two amendments, so you're saying, for example, the example that you gave, the gentleman tried to have, the attorney had tried to try the President of the United States because he used the birth certificate.
Yeah.
So were they saying because that was the first, I guess that they...
No, that had nothing to do with either of the amendments. What it had to do with is we said that the people are not a party in the Constitution.
And that's what I didn't understand. So
Did the attorney that brought the case for Obama to show cause, was he a state? Was he New York or New Mexico? No. Was he the national government, Washington, D.C.? No, so he has no standing to take a discrepancy in the Constitution into any court. He has no standing to be there because he's not a party.
Party of the Constitution is the states.
If you guys have a question, why don't we have you step up to the mics so that it gets on the recording for your own benefit.
Okay, those are aside issues, but they're important because of what we're going to discuss. So let's go back to the trust. What we have here now is in the private, what happened is when they took lawful money away from the people in 1933 by demonetizing gold and silver, they said, well, no longer is gold going to be money of account and we're going to confiscate it. What they did is they took away your capacity to exchange lawful money for property since you're going to pay for property with no lawful gold or silver. What kind of substance are you tendering to the seller in order to acquire the property? There is nothing. You see, a Federal Reserve note is not money, it's a promise to deliver money. It's evidence of a debt. Never understood why people go rob debt from banks. They don't have enough yet, they want more. Okay, so can you purchase a title with debt? No, so after 1933, the presumption was any property that the title changed hands. Nobody gave substance to the seller for the property they were acquiring. You've heard the expression, you only get what you pay for. If you don't give substance, you don't get substance. So after 1933, any American out there buying and selling any property was presumed not to have acquired legal title in the property, right? And so who has legal title if you don't? Well, under the law of escheat, it goes to the government.
Escheat?
And the government only acquires legal title as a trustee on the presumption to hold it in trust until the real title holder shows up. So they're not stealing the property, they're just holding it in trust until the real party shows up and proves he's got a claim. So after 1933, any exchange of any property in America, cars, clothing, food, gift, service, real estate, was presumed no longer did the American have legal title. But you see, they really did something weird because they can't take legal title in the Republic, because what authority did they have to extract lawful money from the people in the Republic? They had none. So they couldn't do that. But what I'm saying is they had to shift the way they were going to do commerce, because with no lawful money, they couldn't do commerce in the Republic. Remember, Article 1, Section 10, no state will make anything except gold and silver, a lawful tender, and payment of a debt. And they have no right to repeal that provision in the Constitution unless they amended the Constitution. Where'd they amend the Constitution and say that the states don't have to operate with gold and silver? They never did, so it's still law, right? Okay, so they had to create something here.
What about the Federal Reserve Act?
Well, the Federal Reserve Act, all it did was create a public trust to secure the securities of the public government for the private creditors. That's all it did. It didn't change any of the Constitution with respect to lawful money. Okay, so what happened is they went about doing something on the public side because the public moved below the line. What moved below the line is they had to be able to use debt instruments for commerce, and they could do that if they moved it to Admiralty Maritime, because we never trade internationally with gold and silver on the high seas. All we do is use commercial paper. Bills of lading, invoices, packing slips, yada yada, promises to pay, everything else. That's all commercial Admiralty paper, straight out of the Uniform Commercial Code, which came out of law, merchant, and everything else that's been going on. So all public commerce was moved below the line. We'll get to the rest of that here in a minute. But they still had to retain what was happening above the line, and they had to move that in such a way that it would be in harmony with the new commerce below the line. And so what they did is they had a private trust up above the line, and what they did is they induced Mom into granting them an application for a birth certificate for Junior. And what Mom was doing, now Mom is feminine, so she's on the Admiralty side, not the common law side. So they induced Mom to do what? Sell Junior's future estate. What are we always being warned about in Scripture about giving up what God gave you? Selling your birthright? Mom sold your birthright to the public government. In return for what? A trust and some benefits. But isn't that what everybody was induced to do in Scripture? Sell us your estate and we'll give you a pot of porridge. Okay, so Mom was induced to do this. Okay, why did they induce Mom to do that? Let's quickly go back to the history. Remember, understand the history, understand what's going on, understand yourself, and then understand your remedy. What is the Constitution of the United States of America? If you look in Black's 7th or 9th, I've got both of those, I know it's in there, look up the word constitutor. A constitutor is one who passes on his debts to a third party. What was the purpose of the Constitution? The national government needed to pass on its debts to whom? The states. So the purpose of the Constitution, most specifically in the 6th article, all debts incurred prior to this act are in full force and effect. The national government's debts were passed on to the states as sureties for that debt. So what the national government induced the states to do in improving the Constitution was to sign on as co-signers for the national debt. That was its purpose. Why? Because in 1789, the United States had a debt to the international banker, Rothschild out of Paris, France, which was owed on principal sum loaned by the King of England to the new republic to do what? To pay our war debts. Well, we beat his ass, and politically he went home, and we won the political conflict. Then we borrowed money from him to pay off the suppliers on the war that creamed his ass. Anybody seen the movie The Patriot? What did the British general say to that idiot colonel? Treat these people nicely, because after the war, what? We are going to be doing business with them, because we won the war in commerce, we lost the war in politics. Which war would you rather win? What happened to Wallace and the history that's told in that movie? Every time the people went out and beat off their enemies, what did their politicians do? Go out and give away the victory in terms of the treaty. Isn't that what they did all the time? So America won the war for political independence, and the founding fathers of necessity went out, borrowed funds which they couldn't pay back. Doesn't Scripture say that the lender is the head and the borrower is the tail? So in 1789, with the passage of the Constitution of the United States of America, the national government became an habitual debtor in international commerce, which means it never did have any real sense of sovereignty. If you can't pay your bills, what makes you think you're sovereign? Now, when was the provisions of the Constitution first invoked? 1933. FDR came in and took his oath of office March 5th, 4th. And in January of 1933, he called all the governors of the states into a private conference and said, you remember the Constitution that you guys are a party to? When I come into office, I am creating a bank holiday, and you guys are going to bring me all the state assets to settle, and close whatever part of the debt we can settle. That was the states. What assets did the states bring in? Whatever assets the states were in control of. Is a trustee with legal title and control of property?
Yes. And
Yes.
in fact, it's the trustee's duty to discharge the debts of the trust using the collateral of the trust.
Can the trustee use the collateral which is already unpledged with any liens? And can the trustee go out and borrow funds on the unpledged equity of the collateral in the trust? Yes. What were the state's trustees over? Any property you people registered. You've registered your automobile? State is a legal trustee. If you've got your car paid off It's got a value of $10,000. You don't think the state hasn't appraised the value of your automobile? It's registered in their system. They can go out in a heartbeat and borrow probably up to 80%, $8,000 against your car. You don't even know the state has got it liened. You voluntarily gave them that power. Mom opened up a birth certificate account. The birth certificate account said, we want to take little Junior's future, dump everything little Junior makes for the rest of his life into this trust, and we're giving it to the state for legal title control. What is the future of your estate interest if you're Junior at age 5? How much are you going to be expected to earn in your lifetime? How many homes, at what value? How many businesses? How many cars? Is the insurance tables going to say Junior is worth? Is Junior going to be worth $15 million in his lifetime? Do you think the trustee can go out and say, who would like to loan me $10 million in advance on Junior's future estate?
I will.
Do you see what happened in 1933? They were already inducing mom and dad to register the children as a birth certificate so that the sum total of their estate would be controlled by the state, so that the state could do what? Go to the bankers and borrow money. Under the Constitution, was your property automatically pledged to underwrite the national debt? No, you're not a party to the Constitution. But if you voluntarily registered your property with the states who, under the Constitution, are required to come to the rescue, then did you voluntarily pledge your property when your mom created the birth certificate so that the national government could use it to underwrite the debt? You bet. Does the government operate on taxes? No. What the hell are the taxes for? Well, first of all, you got to understand what finances the government. What finances the government are bank loans based on the collateral. What's going to pay back the bank loans? Oh, we'll collect taxes and that'll pay back the banks. Everybody is complaining that what is Obama going to do with taxes? He's going to shift massive amounts of wealth from who to who?
The have-nots to the haves?
Well, you know, it's very interesting that a new Robin Hood is coming out. We're going to steal from the rich and we're going to give to the poor. Why? Why would they bring that movie out right now? You see, taxes are not going from the rich to the poor. Taxes are going from the debtors
To the creditors.
to the creditors. Who are the debtors? The ones that are getting public benefits. Who are the creditors? The ones that have loaned money to the government to finance operations. Well, then that sounds like the banks have loaned the government money based on the securities that we've all registered, and now we got to collect the taxes to pay the banks. Voila.
Okay, we got to take a break. Let's do a half-hour break.